We are here this morning in front of the Polunsky Unit, one of 60 prisons operated by the Texas prison system. This unit houses Texas's death row, which holds about 450 men who have been condemned to die for crimes they were convicted of in the state of Texas. We would like to believe that all of these men are guilty and received fair trials during the process. However, recent experience shows us that this is not the case. We know that the Texas system selects minority group members, poor people, mentally impaired, and juvenile offenders to sentence to death. There are no rich folks on death row in Texas.
And the state of Texas just murdered him.
I could live to be 100 years old and try to become the most evil person in the world, but I still wouldn't be able to develop a system that treats another human being so barbarically as I saw a few minutes ago inside the Walls unit.
And this hasn't helped anybody. It
No.
hasn't brought anybody back.
No.
It hasn't changed anybody's life.
No.
It's just taken life away.
The one thing that we have to be concerned about, lawyers talk about fair trials, and obviously those things are important, making sure that defendants are well represented. But the one thing, hopefully, that we all have in common with each other, just as people, is the desire to make sure that we don't execute innocent people. That should be our baseline goal. And that's a goal that is simply not being served by the system as it exists today in Texas.
I was a 19-year-old kid in the 70s, had long brown hair. My father made a career out of the Army. We just moved to the United States from Germany, and started running away from home. I got into computer, I stole a sheriff's car, and to make a long story short, I was living in Tyler, Texas at an apartment complex. I met this girl at a swimming pool. She invited me back to her apartment. I went back with her. It's early June 1977. We engaged in some dialogue and some petting. She placed hickeys on my neck. I told a few individuals who had seen the hickeys on my neck. I called her by name, Linda. I met her at the pool. 2 months later, that day, early June 1977, I entered the patio door with her and left. 2 months later, my fingerprint is matched up. I'm already in the computer for the stolen cars, and I'm arrested for her rape and mutilation murder. The rape and mutilation murder of Linda Jo Edwards, based on the fingerprint. The police detective named Doug Collard, who originally lifted the fingerprint, committed perjury. It was in a secret document. Years later, the prosecution had hid this, that he aged the fingerprint. He said the fingerprint was 6 to 12 hours old, when in fact there's no scientific way to age fingerprints. And before a licensing board, the International Association for Identifiers, in his cover letter, he said he would answer to the board for his perjury, but that he asked that the document be kept from the public domain, and certainly away from any defense attorney representing Kerry Max Cook, because it could have devastating repercussions for the prosecution's case. And Paul Nugent actually has that document. And the eyewitness there was only one eyewitness to the murder. She originally identified a man named James Mayfield, her married ex-lover. And my legal odyssey spanned 22 years, nearly 4 trials, and went on to be caught called the worst case of police and prosecutorial misconduct in Texas history.
Well, you know, it's hometown cooking, and so much of, you know, when you try to figure out who lives, who gets life in prison, and who dies, a lot of it's just pure happenstance, what county you're prosecuted in. Houston is in Harris County, Texas. In Harris County, Texas, we put more people on death row than any place in the country. Houston, Harris County, Texas, the epicenter of the death penalty in America. Galveston County, our neighbor to the south, we border Galveston County. If a citizen is accused of murder in Galveston County, of capital murder, the district attorney's office there routinely offers life. So if there is a capital murder committed and the body's on the Houston-Harris County line, if Houston takes jurisdiction, chances are you're going to death row and ultimately death by lethal injection. If Galveston County takes jurisdiction, chances are you'll be able to negotiate a life sentence.
I don't know that there's a top 10 necessarily in response to a question about why the system needs fixing. But I can tell you there are reasons which still exist in our system that make for the right ingredients for a person to be found guilty of a crime that they didn't commit. I mean, let's take, for example, someone who is black, who is poor, who is uneducated, who lives in a certain area of town, that you have certain police officers whose attitudes are that we're going to do what is necessary to get a conviction. You combine that with a DA whose sole existence in public office is to make convictions, not to seek justice. You combine that also then with a defense counsel that's been appointed who could care less about the defendant, who has no reason to believe that his client is innocent, and who thinks that everybody that he represents happens to be guilty, who decides not to provide the kind of defense that someone who came to him with money could provide. You combine that with a judge whose idea is that, look, I've got to run for office, and so I can't be seen as being coddling to criminals. I've got to be tough, I've got to be firm, and I've got to get a conviction, and I've got to make the conviction stand. You combine all of those elements, and then you begin to understand why we have a system that allows innocent people to be caught up in it in the first place, and then later to be found guilty, and then even later to be executed for a crime that they did not commit.
And when I, pick up a death penalty case, especially in certain areas of the state, my first question is not whether there was any prosecutorial misconduct, it's more where was the prosecutorial misconduct, because you just know that there's going to be some.
The laws, both the federal and the state laws, are stacked against someone after their conviction becomes final. If you have been convicted and lost your appeal, and you're now seeking to overturn your conviction because of new evidence or constitutional problems, the laws are extremely detrimental to you. You have to prove much more than you used to. You have a much shorter time to do it, and so trying to find evidence that's been hidden or even trashed is much more difficult because there's less time to do it. And if you get a hearing in state court and the judge finds against you, it is almost impossible to get a hearing in federal court. So if you have a state judge who is not prepared to give you a truly fair hearing and rule fairly for you on the facts because of concerns about the political repercussions, it makes it almost impossible to get a hearing in federal court where the judges have lifetime tenure and where often you have a better chance of getting a hearing that actually gives you a serious opportunity to contest the circumstances of your conviction. That changes in those laws would require major changes in legislation at the state and federal level.
From the 23 years that I've done this work, I have never seen a case that has been tried fairly enough to be worthy of what we're doing. There certainly are degrees of fairness and degrees of reliability. Every case is not as bad as Kerry Graham's case, but every case has something seriously wrong with it.
Quote, here the extent of the prosecutorial misconduct is legion. There is no doubt in this court's mind that the verdict would have been different had the trial been properly conducted. The police officers and the prosecutor's actions were intentional, were done in bad faith, and are outrageous. These men and women, sworn to uphold the law, abandoned their charge and became merchants of chaos. Their misconduct was designed and calculated to obtain a conviction and another notch in their guns, despite the overwhelming evidence that Carrasco, the other man, was the killer, and the lack of evidence pointing to Guerra, Ricardo Aldape Guerra. The police officers and prosecutors were successful in intimidating and manipulating a number of unsophisticated witnesses, many mere children, into testifying contrary to what the witnesses and prosecutors knew to be the true facts. The cumulative effect of this misconduct violated Guerra's right to a fair and impartial process and trial.
In the area of adequate representation, it seemed to me, of course, Texas is infamous for providing counsel that actually slept through capital murder prosecutions and trials. And of course, that is as inadequate counsel as you can have. But on any number of levels, we found that counsel was lacking and just not performing as they should have performed under their requirements of the Sixth Amendment. We saw in the second area of prosecutorial and police misconduct, I guess the most egregious case that I saw while I was on the Court of Criminal Appeals was the case of Kerry Max Cook, an individual that was tried 3 separate times. And the prosecutorial misconduct there was just beyond the pale from what anybody would expect or demand from their local prosecutors and police work. And unfortunately, that individual spent, I guess, 2 decades or more of his life on death row. And the third thing we saw was that as far as it relates to jury instructions is oftentimes the jury was not told what a life sentence meant. And a jury was told or formed the belief just from anecdotal data from perhaps their neighbors or family members that if they gave an individual a life sentence, he or she would be released in 15 or 10 years or even smaller period of time. Where the truth is, an individual who's convicted of capital punishment in Texas must today serve at least 40 calendar years before he's would even be considered for parole. And jurors weren't known that, and because they didn't have that adequate information, oftentimes jurors would kind of err on the side of caution and say, well, let's go ahead then and impose the death penalty because that way we're sure that the individual will never be released back into society. The fourth thing I saw about judicial review is it seemed to me that increasingly in the 8 years that I was on the Court of Criminal Appeals that the judges there just provided lesser and lesser review, and it became more of a rubber stamp of affirmance for the prosecutions. And of course that's wrong because you've got to have some type of judicial oversight to make sure that the constitutional rights and protections of all individuals are enforced. And I think the Court of Criminal Appeals, quite frankly, and I said this in a number of opinions, just dropped the ball and did not perform as it should have and did not discharge those responsibilities. And fifth and finally, I think the clemency process is something that has received very little attention, probably zero attention since the execution of Carla Faye Tucker. But it seems to me that that process is woefully inadequate when it is supposed to be the fail-safe in our society to make sure that no person is wrongfully executed.
Dallas County, has a history going back to the 30s, and starting I think in 1942, there were actually 3 United States Supreme Court cases directed, that came out of Dallas County on this subject. And the last one was Cassell versus Texas in 1950, and the Supreme Court said jurymen should be selected as individuals and not on the basis of race. Shortly thereafter, the Dallas County District Attorney's Office wrote a manual that said about jury selection. Do not take Jews, Negroes, Dagos, or Mexicans, no matter how rich or how well educated. That manual was revised in 1969 with slightly less offensive language, but it still said to not take minorities because they empathize with the accused. We've been able to document that that manual was being distributed to new prosecutors up until 1980. That doesn't mean it wasn't being distributed, even after that, but we know until at least 1980 we can confirm it.
After meeting with Christopher and talking to him and his family, learning a little bit more about him and his background, I realized that if this could happen to someone like Christopher, it could happen to anyone. It could happen to my son. And after Christopher told me that the police detective interrogated him for 12 hours straight, threatening him, sticking a fountain pen in his arm, telling him that's where the lethal injection would go, actually threatening him with the death penalty, which is supposed to be a deterrent, and the police are using it as a threat to coerce confessions. They threw metal chairs at him, told him they were going to take him downstairs where he'd be fresh meat for some real veteran convicts. Told him, Richard's in the next room. Whoever confesses first is going to get life, and the other one's going to get the death penalty. And Chris was literally terrified. Literally terrified. He was a young Catholic boy, never been in trouble, never even been inside a police station. Same with Richard Dansinger. He had one check he stole from his mother that he got in trouble for. But 18 years old, not a juvenile record, nothing. But Richard Dansinger is a very strong, dominating personality, and he just told him where to go. Whereas Christopher, extremely shy, very timid, and easily terrified. They knew they had an easy mark when they got Christopher Ochoa.
And the question that people need to ask themselves, I think, is, if I were the one accused wrongly of a particular crime, what kind of procedure would I expect? What kind do I think I deserve? And if I couldn't afford one, would I want to have a lawyer appointed who could at least do a minimally competent job for me?
The execution of Gary Graham was based on the eyewitness testimony of one person. In the face of what I consider to be, as a former prosecutor, a mountain of evidence that he was not present when this murder was committed.
In the criminal justice system, when someone is poor and doesn't have the ability or wherewithal to hire their own attorney, the court then appoints you an attorney. Unfortunately, sometimes the attorney that you're appointed is either fresh out of law school or incompetent, never tried a capital murder case. And capital law is, as any attorney can tell you, capital law is quite different than conventional criminal law.
In the words of a very great death penalty lawyer, Stephen Bright, you get the death penalty a lot of times for having the worst lawyer and not for committing the worst crime. You know, some of the cases that we've seen have involved lawyers who were drunk, lawyers who were doing drugs during the trial, lawyers who even slept through trial, and you know, it's tragic because many of these people wouldn't have been convicted or wouldn't have been sentenced to death had they just simply had adequate representation.
In far too many cases, those lawyers are not only not qualified, but have actually been sanctioned through the grievance process in the state of Texas. The guy that the defense lawyer, and I hesitate to even call him that, who defended Gary Graham had been disciplined 5 times at the point in time when he was appointed to represent Gary Graham.
And I think Odell Barnes is a case in point. Odell Barnes had defense attorneys at trial who didn't believe him when he said he was innocent, and so they didn't investigate because there was quite a bit of evidence against him. There was it was a rape murder, and his semen was found in the victim, and the victim's blood was DNA matched. It was found on his pants, and so it looked like a pretty solid case of guilt, but he protested his innocence all along. He was appointed in post-conviction proceedings another lawyer who was inexperienced and didn't really know what they were doing and were underfunded, and again didn't investigate it. And it wasn't until he got to the last part of the system in federal court where he finally got a lawyer who would at least sort of listen and investigate. But the problem at that point was that you're stuck with what you've raised in your previous appeals, and you can't bring any new claims. And that lawyer did go out and investigate and found out, in fact, that the blood sample on the pants was, in fact, the victim's blood, but it had come out of a test tube. There was a preservative in it. And the witness who had testified that Mr. Barnes had seen him coming out of the crime scene, it recanted, and it turned out that the prosecution had made deals that it never disclosed to the defense with other witnesses who testified that in a way that was harmful to Mr. Barnes, and it turned out that he was actually having a consensual sexual relationship with the victim. So by the time the investigation, which came far too late for Mr. Barnes, was completed, it seemed pretty clear that he was not the one. But unfortunately, because his trial lawyers didn't do the work and because his appellate lawyers didn't do the work, no court ever considered that evidence.
A system that provides counsel in capital cases without providing adequate compensation and adequate resources for investigation is a system destined to kill innocent people.
We had some counties in Texas that were paying, for example, defense lawyers $50 a day to represent indigent defendants. That meant that you were not going to get the kind of representation that you might otherwise get if you had access to resources.
I learned from firsthand experience, there's 2 forms of justice in Texas. There's Kmart justice for the poor people, and there's Neiman Marcus justice for the rich people. Invariably, what you have on Texas death row, or any death row in America for that matter, are those victimized by Kmart justice.
You need expert witnesses typically in a capital murder case. If you're poor, the court might give you $1,500 to hire a forensic psychiatrist. In this day and age, you can barely get a plumber to do any work in your home for $1,500, let alone a forensic psychiatrist. If you went to Baylor Medical School or the University of Texas Medical School and tried to hire a top psychiatrist with $1,500, you'd be scoffed at. They wouldn't return your phone call. So it's not a fair fight. It's like the Dallas Cowboys playing a high school football team. It is not a fair fight. And if we're going to allow capital punishment in this country, at least we need to attempt to level the playing field. Give the citizen accused adequate legal representation. Give the citizen accused an adequate budget to hire experts.
My entire defense cost $500.
When I asked the question to one of my good friends who's in the legislature of whether or not he thought we had executed anybody who was innocent, for example, this friend said, well, Harold, I suspect you're right that we have executed innocent people. But I think in the interest of justice, we have to sometimes err on the side of executing innocent people. I thought that was the most telling comment I'd had from anyone, because it shows an insensitivity to the way even courts have sometimes thought about innocent people.
We have executed innocent people in Texas, there's no doubt about that, and we'll continue to execute innocent people. The system is far from foolproof. The system has serious shortcomings, and as long as we have, if as a society we are going to sanction state killings, we also have to sanction killing innocent people, because innocent people will be, as the military says, collateral damage.
I think we need to stop for a while. Maybe that's a good term, you can take it. I think we've got some loose ends. It's like the plea bargain system has really put a lot of people to death. I mean, that's one of the systems I think we've looked at, needs to be looked at. That so often the first one who turns state's evidence, if you want to call it that, will get a 20-year sentence. The very first man that was put to death, his fall partner got out later on, and then he committed another crime, and he came back to our unit, and he was my shoeshine boy. But he would never talk about Charlie Brooks. He wouldn't know about it. And I think the justice system, maybe in that case and in others, listen to the first one who will change their mind.
We as Americans, we try to portray ourselves as being a nation who are concerned for its peoples, but yet and still we have what we use as capital punishment. We're executing our own citizens, we're executing the mentally retarded, we're executing the innocents, and we all know that once you execute someone, you cannot bring them back. And I would like to say to the masses of people here in America that we must stop falling prey, which we are victims as well, because we allow politicians to play on our emotions and tell us that capital punishment is a deterrent when we in fact know that it's not a deterrent, because crime is still running rampant in this country, and we should be able to set an example for other countries. But yet and still, we are doing what we blame those other countries for doing. And two wrongs don't make a right. And I don't think that anyone should have take the pleasure in putting someone to death. I've never believed in capital punishment, and not only because of what I've been through, I was always taught that you should never have the right to take a life. And we should be able to treat one another with dignity. And at least just because someone has been indicted and charged with a crime does not make them guilty.
After working with Gary Graham and on his case for 7 years, between 1993 and 2000, I came to a professional and personal conclusion that Gary Graham was innocent. He was not innocent as the driven snow. He was guilty of a lot of other crimes where people were hurt, where their property was destroyed, where lives were messed up. He acknowledged that from the very beginning. He did not kill Bobby Lambert. It was a grievous mistake to convict him of that murder, to to sentence him to death of that murder, and to turn a deaf ear and a blind eye to all the evidence that pointed to his innocence of that murder from 1993 to 2000. Texas put to death an innocent man. George Bush was in the middle of a political campaign that could not acknowledge that Texas had made such a grievous mistake. And so he compounded it by letting the execution go forward. He allowed an innocent person to be executed, quote, on his watch.
I don't care when the proof of innocence come out. I think they need to, hear it. Put it in somebody's courtroom. We knocked on courtroom after courtroom after courtroom, trying to get off into a courtroom, and they never would let us in. They would always turn us away. And I do know in my heart, if they would put us in court, my child would be here with us today.
We, like it or not, we are in Texas and in the rest of the states of the old Confederacy, we come from this slavery heritage. And there are vestiges of that left. And why is it in Texas and why is it in Dallas, Texas, that a white has never been prosecuted in a capital case for the death of a black? Answer that. The only answer is it's endemic racism in the system.
There's several areas in capital cases where race and criminal justice intersect. And really it starts at the very beginning of the process. That being the decision to seek death. Lots of cases, lots of murders happen in this state that would qualify under the statute for a capital prosecution. And then it's up to the individual prosecutors to decide when they're going to seek death and when they're going to seek something less than death, or when they'll agree to some sort of a plea bargain. Statistically, if you are a black man who kills a white person, you are 8 times more likely to be subjected to a capital prosecution.
Well, the composition of the jury was all white. In both trials, it was all white.
And doesn't sound like that was a jury of your peers, so to speak.
Most definitely, it was not a jury of my peers.
Mentally retarded people, through no fault of their own, have the same intellect in many cases as children. So, for example, Johnny Paul Penry, I believe the testimony was that he had the mental and emotional age of a 7 or 8 year old. And surely, I think even the most vigorous proponents of the death penalty would not stand for the spectacle of taking an 8-year-old child and executing them, no matter what that 8-year-old child does. And so it's important that people see that although Johnny Paul Penry and other mentally retarded people may look like an adult, they are in fact not an adult in their brains, and holding them to that same level of responsibility is just as cruel as it would be to hold a 7-year-old child responsible.
I remember when we were talking to the television crew, and they asked us if we were going to hire a lawyer, and I said, we've been told that we can't afford the kind of lawyer that Larry needs because school teachers don't have that kind of money. But I said, anyway, we don't need a high-priced lawyer. All we need to do is tell the truth. He's mentally ill. And I thought because he was mentally ill, he'd be sent to a mental health facility, probably for the rest of his life. But I was sadly mistaken. We did need Racehorse Haynes. That's who I said we didn't need, but we really did need. We did need a lawyer like that, and because the mentally ill are convicted all the time in Texas. There are many of them on death row. Probably a third of the people on death row are mentally ill or mentally retarded, and they have executed dozens of them.
One part of confessions that is extremely troublesome is that many people who get charged with capital murder have low intellectual functioning. Some have mental retardation. The mental health community has known for years that folks with that affliction have a tendency to confess to things, to terrible things that they haven't done. Partly it's acquiescence to authorities, partly it's that most of their lives are spent being blamed by other people for things they do or haven't done, but get blamed for anyway. And so there's this real vulnerability to taking on responsibility for terrible things that they have not done.
When Oliver was arrested, the statement that came out was very well written, and I mentioned to the lawyers that there was no way that Oliver could have made that statement because of the fact that he didn't know how to read or write. So what happened was I told the lawyers that he didn't know how to read or write, and so they brought in this doctor to evaluate him, and then they talked to the lady at the school, you know, about the school records. They brought out the school records, and they tried to, you know, to match them up to see, you know, if they how they were almost identical. The doctor that came in to evaluate him said he was borderline retarded because he had a very low IQ.
And I think that we've also executed some people who did not understand. You know, like when I would tell them at 10 o'clock, we're going to do this, 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 and they're going to put the 9 straps across here, they're going to put 2 needles in, they're going to put bandages around your hands and explain everything's going to take place, and then you'll be asked to give your final words, and when that's over, the warden's going to take off his glasses, and that's a sign that here comes the sodium trialpentothal. And I said, it'll put you to sleep in 7 to 12 seconds. And I would explain all that, and then when I would get through with that, there were several of them who would say, okay, then when do I go back to Ellis? And they didn't understand that this was going to kill them. They did not know, even after I broke it down after, you know, practicing it, having to practice it, for not only those 95, but there were over 100 more that got stays after I had discussed this program. But for them to say, well, when I go back, we're not mentally there.
Your question is whether when Texas executes a juvenile offender, we are breaking international law. And the answer is that when we seek the death penalty against a juvenile offender, we are breaking international law.
This whole ordeal began back in April of 1994, where Napoleon and 2 other cohorts, 2 brothers, went out and committed a crime up in Smith County of Tyler, Texas. And from that situation, Napoleon was arrested and he was charged with capital murder. And then in 1995, he was sentenced to death by the jury up there in Smith County. But Napoleon at the time of the offense, he wasn't but 17 years old, and but you know, by the time they had the trial and everything, he had turned 18. But we feel like the case was unfair and unjust. A lot of situations because, you know, we felt like Napoleon was too young to be given a death penalty, and also we feel like that the victim that was of the case, he was the father of a federal judge, and we think that was one of the situations that played an important part or important role in Napoleon getting the death penalty.
Texas stands alone vis-a-vis the rest of the world in continuing to give the death penalty to juvenile offenders. Over the last decade or so, every organized government in the world has fully ratified the United Nations Convention on the Rights of the Child, which prohibits giving the death penalty to someone who was under 18 years old when the offense occurred.
That's part of the nature of our system, and it's, you know, it's understandable. The death penalty is extremely political. I mean, we have the death penalty, I think, not so much because it actually helps curb violent crime, but because politicians can get votes for being for the death penalty. It signals being tough on crime, and being tough on crime is an essential element of being a politician these days. I mean, there are not too many politicians who are soft on crime who get elected. And so being tough on crime calls for being tough. And the death penalty is the toughest we can be. And so there is that political pressure to have the death penalty.
What I'm finding is that we're not electing good judges in Texas anymore. We're electing good politicians. And that's not necessarily the same thing.
Careers are made, or careers are lost in highly publicized trials. Clarence's case was front page news in Conroe, and it's very important for the district attorney to win the case. You have to remember, a district attorney is a politician first. We think of a district attorney as someone seeking justice. Well, in theory, that's true. A district attorney should seek justice, but they're politicians. They run for office every 4 years, and they are beholden to the elective process. So a district attorney is first a politician. The pressure in a small town or a small county like Conroe, Montgomery County, Texas, to win is incredible.
It came out during the evidentiary hearing that Judge John Martin, the district attorney Jim Keeshan, and the assistant attorney Jerry Winfrey met in secret to conspire the strategies to keep my attorneys from presenting any evidence that would show light that I actually didn't commit the crime. And Judge Martin is no longer a judge because he's now deceased. Jerry Winfrey became the first judge. He's still a sitting judge in Conroe, Texas. Jim Keeshan, he's a judge now. He's still a sitting judge in Conroe, Texas. And they are still practicing and passing judgment on people in Conroe.
And I know that when Larry came up for trial, the lawyers called me down to the office because they were working on a plea bargain. They thought that they were going to get a plea bargain for 4 consecutive life sentences. And everybody had agreed to it except for the head DA who was out of town. When they finally reached him, he said, no, we can't plea bargain because there's an election coming up, and so we're going for capital punishment.
In so many of these cases, the evidence that has been presented has been really questionable. The use of hair samples, which has been discredited across the country. The use of psychologists who testify repeatedly on behalf of the state. I mean, we had a psychologist or psychiatrist who was so popular among prosecutors that he was actually referred to as Dr. Death. The use even of eyewitness testimony. I mean, the people think of eyewitness testimony, lay people think of eyewitness testimony as very reliable. In fact, that's not the case.
There's a lot of cynicism in Texas, I think, about just the average Texan thinking that there might be individuals on death row who are innocent, or there might be individuals who are on death row simply because of their race or because of their economic status. And when you have that level of cynicism, what you have is an erosion in the public confidence and trust in the judicial system, and that's very bad.
When our firm got involved, Clarence had been convicted after a second trial by a second all-white jury. His case had been affirmed on appeal by the appellate courts in Texas, and we filed what are called writs of habeas corpus. And we contended Clarence was innocent in those writs, and we proved it that he was innocent. The Texas legislature has since changed the law. There's been a political push to speed up executions. And now the law in Texas is you must file a writ of habeas corpus within 1 year of conviction. If that had been the law in Clarence's case, Clarence would now be dead. He wouldn't be with his family. He wouldn't have been free. He would have been executed, although he was innocent.
I think that's going to have to come from those who are conscious, come from the people who have conscience and who are conscious of what is going on, to be man and woman enough to stand up and say, let's stop this madness. Let's stop executing people, period, in this country.
None of us that are up here talking about justice are saying leniency. Nobody is saying that a person who commits a terrible crime, such as what happened to Miss Bass, should be allowed to go free. Nobody's saying that. But that's what happened, because the system was not set to protect Odell Barnes because it wasn't. A guilty guy did go free, and an innocent guy was executed.
As I sit here today, I am not an opponent of the death penalty. In fact, I'm a supporter of the death penalty. I am, however, a person who, because of my involvement with the criminal justice system, particularly during that period, am deeply concerned about the way the system works or does not work in Texas today.
I cannot think of any other area of government, any other area of business where if you knew something was wrong and fundamentally flawed, you would allow that process to continue knowing that mistakes were going to be made. And that's exactly where we are in Texas, and that's why I think a moratorium would be appropriate.
My approach was simply to say, look, while we fix the system, let's put a hold on the system of executing people. If we fix it for someone who simply has a life sentence, it doesn't matter whether you fix it in 140 days or 280 days or 365 days. That person is still going to be around, and so any available fixes that might relate to that person later on, that person still might well take advantage of. But if you find yourself on death row in Texas and your sentence is carried out before you are able to avail yourselves of some of these solutions that the legislature and the courts have crafted that are designed to really fix the system so that you can now prove your innocence, which you might not have been able to do at the time of trial because either the scientific methods of proving it weren't available to you at the time or some other reason you were not able to at the time. But now you can. That is far more critical in the person, in the eyes of the person who is sitting on death row.
I remember my son that last visit, he said, I tried to talk to him different. You know, I tried to talk to him, and he quiet me, and he says, Mother, he says, listen to me. And he started giving me instructions, right? And he said, do you know that God had one son? I said, yes. And he says, do you know that that he died? I said, yes. He says they killed him and he didn't have anything to do with anything. And you know, they still killed him. And I looked, okay, and I tried talking to him and he kept, be quiet, Mom, let me talk. And here's what I want you to do. And I says, okay, and he said, the pain that you're feeling right now is the same pain that Mary felt when she was losing her son. And then I looked at him and he said, I want you to promise me that you'll never stop fighting for somebody. It doesn't matter who it is. You just keep on so that we can get this moratorium. He says, you know that they're doing a whole bunch of stuff right now on my case? And I said, yes. And he said, okay. He said, if you keep on and not stop, we will get that moratorium. He said, Mom, he said, I'm not going to be saved. They're going to kill me tonight. And I looked at him and I said, no, don't say that. We still have some time. He said, no, they will. But you better promise me that you're going to keep on trying so somebody else will be safe and another mother will not feel the pain that you're feeling right now.